Welcome to CivilNet. My guest is Levon Gevorgyan, a lawyer and a PhD in international law. Since the beginning of the Artsakh War on September 27, many human rights violations were committed by Azerbaijan. What can Armenia do in terms of getting justice? Thank you for joining us, Levon Gevorgyan.
Thanks for having me.
So as I said, there were many obvious violations of the human rights by Azerbaijan against Armenians since the start of the war. From indiscriminate targeting of civilians, using banned ammunition, causing an exodus of internally displaced people, and destroying civilian infrastructures. Where should Armenia start? Where should Armenia take these cases? What can Armenia do now?
Well, first of all, I think it would be better to say what Armenia has already done, because steps already been taken. Well, first of all, on 1st of February, if I'm not mistaken, Armenia has already filed an interstate claim against Azerbaijan, raising, according to the publicly available sources, a number of issues pertaining to the Third Artsakh War. Basically, the Article 2 violations under European Convention, right to life, Article 3, inhuman, degrading treatment, torture, property issues, and issues pertaining to the rights of the individuals to return to their homes. In addition to that, even prior to this interstate application, a number of interim measures have been requested by the Republic of Azerbaijan, by the Republic of Armenia, before the European Court of Human Rights, and most of them have been granted. Unfortunately, to a certain extent, it seems Azerbaijan is not that willing to comply with its obligations and is pretty much ignorant of the interim measures imposed by the European Court of Human Rights. Unfortunately, we've even seen a case where an individual has been assassinated, killed, even after the interim measure has been applied. In addition to that, there are, of course, lots of individual applications being filed against the state of Azerbaijan by individual applicants, and there are certain other instruments and other conventions that can be utilized by the Republic of Armenia. It was yet in November, a couple of days after the so-called three-party statement of November 10, that the Ministry of Foreign Affairs announced that the ministry notified the Republic of Azerbaijan about our claim that Azerbaijan is in violation of its obligations under the Convention on the Elimination of All Forms of Racial Discrimination. This is a separate venue that may, in case of certain developments, even lead to the doors of the International Court of Justice. So basically, the convention provides that if one state deems another state to be in violation of its conventional obligations, negotiations need to trigger, and apparently such negotiations need to take place in between Armenia and Azerbaijan because of the notification, and if those negotiations fail, Armenia may take the issue to the International Court of Justice. According to the public statement made by the Ministry of Foreign Affairs, this pertains to a host of issues and not just the incidents with respect to this recent war. It basically pertains to decades of violations by the Republic of Azerbaijan, destruction of cultural heritage, falsification of history, hate speech, glorification of murderers, and people who committed violent crimes based on ethnic hatred, and a number of other violations. There are, of course, other conventions that technically can be utilized as well. The Mercenaries Convention comes to mind right away, given the fact that mercenaries were used during the Third Artsakh War by the Republic of Azerbaijan, with the direct and apparent involvement of the Republic of Turkey. So yeah, there is let's say, a significant portfolio of international legal instruments that can be utilized by the Republic of Armenia to lay its claims and to try to restore justice.
And so far, how many lawsuits are open against Azerbaijan? Do we have a number, or?
Well, as of now, if we're talking about the interstate case, it's just one case before the European Court of Human Rights. There are negotiations triggered under the Convention on the Elimination of Racial Discrimination. As to how many individual applications have been filed or are going to be filed, I will not be able to comment on that. Given the significant number of victims, I think the number is going to be in dozens, if not in hundreds.
And how long such lawsuits can last?
Well, usually, and again, unfortunately, litigation before international judicial institutions is a lengthy process. We're talking about 5 to 10 years minimum. The positive thing is that, at least within the auspices of the European Court of Human Rights, there is a certain discussion and contemplation within the court itself of defining new expedited procedures for interstate claims. If that happens, maybe we can talk about a period which comes up to 5 years, but we're definitely not going to see any judgments in more close future.
One of the most shocking violations of human rights was the decapitation, dead or alive, of Armenian soldiers, but also of civilian hostages. Which sanctions in practice can be imposed on Azerbaijan in the case of lawsuits in the European Court of Human Rights?
Well, if we're talking about restoration of the rights of the victims and as well as their relatives, unfortunately, the primary tool that is being applied by the European Court is the monetary compensation. We're of course dealing with a situation which may be to a certain extent new for the European Court standards, because the European Court is going to deal not only with simple human rights violations, it's going to deal with a host of war crimes, as a matter of fact. And it seems like, at least under public international law, the logical conclusion is that restoration of justice would also imply that there is an obligation imposed on Azerbaijan to exercise proper prosecution and to punish the criminals. Whether the European Court is going to take that path and going to impose that obligation is yet to be seen. Even with respect to the case of Ramil Safarov, we've seen that the European Court has not been very clear as to how the judgment is going to be enforced. Basically, this is a lengthy process that needs to be also taken to, after we have judgments, needs to be taken to the Committee of Ministers within the Council of Europe. And this is not just a legal process, this is also a diplomatic process. So necessarily the Armenian side has to raise the issue that restoration of rights under the convention has to be, implies necessarily also prosecution of individuals who are responsible for this. How this is going to be implemented in practice is fairly difficult to assess, especially given the fact that we're not just talking about war crimes where the perpetrators are individuals of low level. We're talking about war crimes which have been motivated and instigated on the highest possible level of the Azerbaijani government and authorities, given the hate speech, hate propaganda, anti-Armenian xenophobia that has been propagated by the Azerbaijani authorities for decades now, and especially emphasized during the Third War. So this is yet to be seen. This is going to be a lengthy legal diplomatic process, and Republic of Armenia will have to exercise all possible leverages to force justice upon Azerbaijan.
Also, according to Siranush Sahakyan, the lawyer working on behalf of the prisoners' families, Azerbaijan may be holding as many as 223 Armenian military prisoners and civilian hostages, including women. It sometimes seems that this issue is trying to be solved at a regional level. Russia is negotiating with Azerbaijan to push Ilham Aliyev to free the prisoners. Can in the meantime Armenia find a judicial way to force Azerbaijan to free them?
Well, of course, not only judicial but also diplomatic, because this is an issue that needs to be raised also before international organizations, the United Nations, etc. Azerbaijan, from the moment of the end of the war, was very active in claiming that these individuals are allegedly terrorists, criminals, whatever. But in terms of legal substantiation, of course, these claims are pretty much nonsensical. But at the same time, it's obvious that Azerbaijan is trying to keep these people, maybe in order to exert certain political pressure, or in order to build up an alleged counterclaim in case the Republic of Armenia files a claim against Azerbaijan based on the Mercenaries Convention, because at least in one letter to the United Nations, Azerbaijan has claimed that allegedly these individuals are mercenaries, which is complete nonsense given the fact that, as far as we understand, predominant majority of those individuals are Republic of Armenia and Republic of Artsakh nationals, citizens of those republics, as well as there is absolutely no proof that those individuals have been involved for any monetary compensation. Even if there are a couple of ethnic Armenians who have Syrian or Lebanese nationality, maybe, theoretically, those individuals are apparently volunteers, which has nothing to do with the Institute of Mercenarism. In terms of judicial proceedings, the issue is definitely raised within the interstate claim, according to the public information that was made public by the Armenia's representative before the European Court of Human Rights. So the status and release of those 200 plus individuals is part of the interstate claim that is filed before the ECHR. It's also a matter which is discussed within the scopes of the interim measures, but again, unfortunately, this cannot be solved through legal venue only. All diplomatic efforts need to be utilized.
Azerbaijan also launched lawsuits against Armenia for war crimes. What can all this lead to? Where can all this lead to?
Well, apparently Azerbaijan is cognizant of the fact that in a long-term perspective, it is going to get a host of a number of judgments against which find Azerbaijan in violation of significant obligations under public international law. So apparently what Azerbaijan is trying to do is to create certain kind of noise and to mirror everything that the Republic of Armenia is doing against it. So basically, and I'm pretty sure this is not going to be the only case filed by Azerbaijan. It's going to mirror everything that the Republic of Armenia is going to do. This is being done for the purpose of gaining midterm successes, because through this, it basically creates the smokescreen that everything that Armenia claims that Azerbaijan has done is pretty much reciprocal and something that can be attributed to both sides. Again, Republic of Armenia needs to counterbalance this not only through judicial mechanisms, but also through lobbying efforts, through PR, etc. Because apparently Azerbaijan is investing an enormous amount of funds into creating this smokescreen, and it's not a fairly, at least for Azerbaijan, it's not a fairly big budgetary concern to spend a couple of millions to hire top law firms and top lawyers and to prepare a couple of such claims, which apparently are not going to lead anywhere. Especially, to the best of my knowledge, the claim that has been filed by the Republic of Azerbaijan against Armenia, at least 70% of that claim has nothing to do with the recent war, but pertains to alleged violations during the first war Artsakh War, which is a period which actually predates the time when the European Convention was ratified either by Armenia or Azerbaijan. So even assuming that allegedly certain violations are really raised there, the prospects of the European Court addressing these violations are very, very small. So apparently, again, Azerbaijan is attempting to create this smokescreen that Armenia is the party which is in breach of its international obligations, but time will show everything.
Okay, thank you very much
for
this talk. Thank you for watching and continue to follow CivilNet.